Welcome back to the show, everybody. We got some exciting news for you. We have Ripple update letter from the SEC Ripple case, and there is explosive information in there. They actually believe that they have evidence that they need to get a hold of that the SEC is trying to hide because it can be exculpatory, which means it can absolutely dismiss this case for Ripple probably immediately. That's how strongly they feel about it. And then we've also got a letter to Congress from Ripple, which is straight fire as well. If you thought Ripple was taking this sitting down, you better think again. Somebody roll that beautiful intro.
This is Digital Perspectives with Brad Kimes. Subscribe for new content notifications. Now, here's Brad Kimes. Come on in.
Welcome back to the show, everybody. You can follow me on Twitter at BackupBradleyAbove, and everything that we're talking about here today. We're $1.881 trillion cryptocurrency market cap. We're at 1.47 this morning. Bitcoin sitting at 42,000 plus, Ethereum at 2,900 plus, Cardano at $2.13, and XRP is 92 cents this morning. Let's go ahead and take a look at this. Forget the price range. I want to get time enough to be able to keep this short and tight, this video, and go over the pertinent information that we've got for you this morning on the case. Peruvian stablecoin launches on the Stellar blockchain. Well, isn't this interesting? Stellar, same code, same creator from the XRP ledger, working with banks to issue stable coins for Peruvian, Latin American stablecoin issuer ANCLAP is expanding its Stellar blockchain based on stablecoin network by launching a new stablecoin pegged to the Peruvian dollar. Now, I have to say, we just heard Bhutan is launching their CBDC. Not quite the same thing, right? Obviously, but I'm seeing a huge correlation between the XRP ledger usage and the XLM Stellar blockchain network. I mean, this is pretty remarkable. So let's go ahead and keep going very quickly here. So then we see the governing body that oversees credit unions in the U.S. looking into how to regulate digital assets. Credit unions have made it clear they want regulatory clarity that allows them to participate in digital assets. Now, let's check this out very quickly here. It says the governing body that oversees credit unions in the U.S. is looking how to regulate digital assets. They made it clear they want access to it. The National Credit Union Administration asked for opinions on how to approach digital assets. Credit unions said they are ready to for a seat at the table. The NCUA, an independent federal agency responsible for overseeing the United States and roughly 6,000 federally insured credit unions, issued their formal request about how the financial institutions can and will interact with cryptocurrencies on September 23rd. Come on in. If you remember, the CFPB, which is the Consumer Financial Protection Bureau, July 20th, July 21st in 2020, actually passed an amendment that made it okay to use Swift GPI and Ripple XRP, or cited that they could be used for the first time in cross-border transactions with credit unions and banks, because they were able to have transparency on the payment before accepting it between the sender and receiver. So that is something to note. Why I wanted to show you that before we roll into the next piece of news here, which is James K. filing. And first, we're going to take a look at the letter that was submitted by Ripple to these congressional officials, including Senator Toomey. Definitely worth reading here. We're not going to read the whole thing on this, but this is what I want you to see is this thread from Stuart Alderati, where they ask for feedback on crypto blockchain laws. Here's Ripple's response. They want to encourage innovative sandboxes for crypto, increase public-private collaboration, engagement and consideration by Senate of existing legislative efforts. It all comes back to clear regulatory frameworks that allow innovation to flourish with consumer and market protections. We don't have clarity today in the U.S., despite those who insist or incorrectly suggesting otherwise. Thank you to Senator Toomey for engaging with the industry. Now, if we go here to the letter itself really quickly here, I wanted to take a look at this because it's a 5-page letter, but I want to look at the page 2 in this particular area. Listen to how they go down into these points here. Innovative sandboxes should be fostered and encouraged in the cryptocurrency space to determine if different tokens in the cryptocurrency space are investment contracts, securities. The SEC purports, to be applying to the Supreme Court's 1946 Howey case ruling, but rather than simply applying Howey, the SEC issued guidance in April 2019. That guidance has been criticized by many, including the SEC Commissioner Peirce, who compared it to a Jackson Pollock work insofar as it splashed lots of factors on the canvas without any clear message. Well said. Even Securities Exchange Commission Chair Gary Gensler, while at MIT, stated that while he held certain views about the regulatory status of various tokens, it was not his opinion that mattered, and the issue was deserving of a worthy public debate. He went on to add that for XRP and other big market cap tokens, there needs to be clarity in the market. Tell me that they're not listening to all of us and the things that we're sharing. This is really remarkable for them to make these points to Senator Toomey and others. As a way forward, Commissioner Peirce has proposed for consideration, as we know, safe harbor, under which network developers would be exempt for 3 years registration provisions of the federal securities law, during which time they would be allowed to launch their products and develop their networks through token transactions. At the conclusion of the 3-year period, the token transactions would not trigger securities registration requirements if it is determined network maturity has been achieved. Fraud, of course, would not be subject to any protections. While the proposal does not seek to solve every regulatory problem in the cryptocurrency space, including how to deal with hundreds of projects already in existence, it's a prime example of how public-private collaboration could form the basis of rational regulation through a sandbox approach. We have said this a million times. Give us a sandbox before you pass the legislation. Let's have 12 or 18 months go by so we can see what works and what doesn't, right? Find out which applications actually find use case, utility. Then you shape the market with legislation based on what is actually working, right? And what falls to the floor. Okay, so going on here, I'm not going to read the whole thing, but I do want to go to page 3 for a second here, because I want to go to this spot right here where it talks about what they feel is important for Congress to focus on should they take a look at the stuff. So in addition, H.R. 1602, the Eliminate Barriers to Innovation Act, Ripple believes there are at least 2 other proposed bills that merit equal consideration, and that is the Securities Clarity Act, which we've talked about here from Tom Emmer. Very, very light touch, but puts the SEC back in its own lane. And the DCEA, which is the Digital Commodities Exchange Act, which really helps to sort out who oversees the actual crypto exchanges, the digital commodity exchanges. It says here, the Securities Exchange Act, reintroduced on a bipartisan basis by Tom Emmer, Darren Soto, Ro Khanna earlier this year, seeks to address ambiguities in the SEC's application to digital tokens issued as a part of an investment contract. Specifically, bill proposes new terms, investment contract asset, and makes clear that such assets should be considered separate and distinct from the securities offering they may have been a part of. That is, digital tokens are not transformed into securities merely because they were issued in connection with an investment contract. Rather, the bill clarifies these assets are in fact and always were commodities. This is the simple language that can be put into place to make this so clear that they cannot, the SEC, they cannot step in the way of this market. Looking right here, I wanted to point out one more thing of this here, where the DCEA, the Digital Commodities Exchange Act, and if you don't know, there's a CEA, Commodities Exchange Act, just like there's a Howey Act or Securities Act in the SEC. So this would be a complementary piece of legislation passed to the Securities Clarities Act to seek to create federal definition of digital commodity exchanges and charges the CFTC with the authority to register and oversee them. So this would put all the exchanges under the CFTC and not the SEC the way Gary Gensler wants. The question here is of many questions, right? Is why in the world is no one from the CFTC have a voice on this? We should be hearing the CFTC in a louder version of Gary Gensler even. saying, hey, man, this is our sandbox. You get back over and play in your own sandbox. There's no one that it appears, at least publicly as Gary Gensler's been, out here front-facing from the CFTC to defend their ground for these exchanges. And that, I think, is a question that needs to be pursued here. Now let's move on to what could be explosive information and exculpatory evidence for Ripple, which means it could quite possibly dismiss this case immediately. That's what that really means. So take a look at this from James K. Filan here. Shout out to you. Ripple files revised response to the SEC's brief regarding alleged privileged documents SEC is withholding. Ripple hits on the SEC's continued efforts to re-argue issues that the case has repeatedly been rejected. Now take a look at this, because this is just, I'm going to give you the first 2 pages here, and then I think you got it. Right? So just listen to this. This is right here. So defendants Brad Garlinghouse, Christian Larson, and Ripple Labs respectfully submit this response to the SEC September 14th. Right? So regarding the documents over which the SEC has asserted deliberative process privilege known as DPP, and the court has directed be submitted for in-camera review. At the August 31st hearing, the court directed the SEC to submit in-camera the documents logged on Appendix A, and that the parties then submitted targeted letter briefs on those documents. The court did not invite the SEC to relitigate the issues decided at the April 6th hearing and reaffirmed the court's May 6th order, including the relevance of the documents withheld in the DPP grounds. Look, this is clear sign here, and I'm 12 years short of a law degree. But what I do know is, as a layman, the SEC is terrified of anyone seeing these said documents. If you're continuing to relitigate what has already been made a decision by the judge, and you continue to try to relitigate these points to not look at them, please don't look at them. Please don't look at them. Nonetheless, the SEC devoted much of its response to arguing these points. Contentions in the court has already rejected on several occasions. The SEC has also raised 2 new points on relevance that can be readily disposed of. First, the court should not credit the SEC's ex post assertion that it chose to waste the court's and the defendant's time by including almost exclusively non-responsive documents on its privilege logs. In other words, they just threw a bunch of and but and the documents in there that meant literally nothing, try to satisfy the actual requests for the documents themselves. It says here, privilege logs contain only documents that the SEC identifies as responsive to the court's order compelling production. Now, the SEC claims the majority of the intra-agency documents logged by the SEC, including all but one of the entries on Appendix A, are not only irrelevant, but also non-responsive to the court's order. Listen to this section here. Many of these documents appear to not only be highly relevant, but potentially exculpatory in that they bear on what the SEC was hearing and discussing regarding the market's interpretation and understanding of the application of federal securities law to Bitcoin, Ether, and XRP. See Appendix A, and then all the entries are named. The SEC cannot now erase its decision to log these documents as responsive simply because the agency fears they may undermine its case. Second, the SEC continues to obfuscate the standard for recklessness eliminate of its own aiding and abetting charges, In other words, try to make it unclear about these charges that they actually put against Brad and Chris. Defendants recognize that recklessness is one of the 2 potentially sufficient mental states alongside of actual knowledge, but the SEC has pled its case as one of recklessness. And to establish recklessness, the SEC must show the status of XRP as a security throughout the entire charged period was so obvious that the individual defendants must have been aware of it. Ooh, I got to tell you, I thought the case was getting strong for Ripple. I mean, now it's getting explosive in my eyes. This is what I'm seeing here. I mean, this is going to be something here. The actions and reactions of others, particularly the world's foremost securities regulator, bear directly on how obvious the regulatory status of XRP was or could have been to anyone. Oh, I have to say, I'm going to stop right there because, I mean, we could go on and on and on, and I probably will cover other parts of this later. But I tell you this is really, really explosive. And I don't know. We have to find out when is the next date for a hearing on, I think it's expert discovery. So we'll see, or if the judge makes some kind of any kind of a decision beforehand. So the case saw one of the most explosive pieces of information that were revealed by Ripple, which comprised of the plaintiff's 2018 XRP analysis. We're going to sum it up here by looking at this article if we could. It says here, the case saw one of its most explosive pieces of information revealed by Ripple, which comprised of the plaintiff's 2018 XRP analysis, proving the SEC's manifold versions of the privileged argument do not stand. Ripple noted that the SEC's division's legal analysis of XRP was made available to certain individuals at the SEC just a day before the controversial Hinman speech of 2018. The SEC's Division of Corporate Finance, a division that operates distinctly from the Division of Enforcement, wrote a memorandum containing a legal analysis of XRP. That memorandum was then circulated to certain individuals at the SEC on the day before the Director of Corporate Finance, Bill Hinman, gave a speech publicly, declared Ether not to be a security. Ripple further discredited the SEC's log privilege documents, specifically the XRP legal analysis, under 3 claims. The defendants discard the attorney-client privilege argument by the SEC, stating that they mentioned the documents are not protected by work privilege as they are not working documents. Listen to this. According to Ripple, the documents in question were never a part of the SEC's investigative file, as the SEC now seems to assert. The defense notes that the investigative documents are already covered by the SEC's categorical privilege log, and unlike these documents, they would not have required any further logging. The very logging of these documents suggests that it is not a part of the investigative file and raises questions about what it is and why it was prepared. Furthermore, the XRP legal analysis documents authors remain anonymous, and the drafting timeframe is also not disclosed by the SEC. Come on in. How many? 63 different email drafts. Who was on them? Who was on them? The only information available is that it is drafted before 2018 Hinman speech, and it was sent by the Office of the Chief Counsel of the Division of Corporate Finance. Lastly, the SEC does not assert that the memorandum was drafted at the direction of enforcement counsel given litigation, only that it was sent to a single enforcement counsel, along with 9 other people who were not in the Division of Enforcement. Which, I'm not a lawyer, but sounds like it breaks the confidentiality and deliberative privilege process, because you went outside of the chain of how to keep it under that DPP, right? There is every reason to believe that the Division of Corporate Finance was looking at XRP status under the securities law independently of considering whether the Division of Enforcement might recommend an action to the Commission. And in short, Jeremy Hogan says it right here. Clever. Ripple argues that the deliberative process privilege does not apply to any of the SEC's documents it does not want Ripple to obtain, because the SEC itself has never deliberated about policy RE digital assets. E.g., Hinman was only deliberating for himself, not the SEC. It can't fall under DPP. Come on in. This is getting really, really good. That's going to do it for me. Make sure you hit the like and subscribe, leave a comment below, share with somebody you know, hit that notification bell so you don't miss a thing, and check out all the links in the comment section and the description box. I'm so excited about this information. And make sure you know that they are products and services I use each and every day, and more importantly, they are trusted, vetted links. Make sure you know what you're clicking on out here, and I will catch all of you on the next one.